It's 3:30 in the afternoon on January 20th, 1843. A man stands on Downing Street in London, watching the entrance to 10 Downing Street. He's been watching this street for days. A man in a black coat steps out. The watcher raises a pistol and fires one shot into his back. This is the case that rewrote the rules for criminal responsibility, and the law still hasn't fully recovered. The shooter is Daniel Megnon, a Scottish woodturner. The man he shoots is Edward Drummond, private secretary to Prime Minister Robert Peel. Megnon believes he's shooting Peel himself. He's wrong. Drummond dies 5 days later. Megnon is seized on the spot, still holding the weapon. At his trial, a different picture emerges. For years, Monckton has believed the Tory party is hunting him. He tells doctors that spies follow him from city to city. He says the Pope is involved. He says the persecution has driven him from his business, his home, his sanity. 9 medical witnesses testify. All 9 agree Monckton is insane. The jury deliberates. Then it returns a verdict almost nobody expects. Not guilty by reason of insanity. The public reaction is immediate and furious. Queen Victoria herself, who has survived multiple assassination attempts of her own, writes to the Prime Minister demanding the law be changed. If a man can shoot a government official in broad daylight and walk free, what exactly is the law protecting? The House of Lords convenes a special panel. 15 judges are summoned. Their task, define once and for all when a mind is too broken to bear guilt. They aren't asked to retry Monckton. They're asked something bigger. When does madness erase a crime? The judges deliver their answer in 5 questions and answers, but 2 lines matter most. To establish a defense on the ground of insanity, it must be proven that the accused did not know the nature and quality of the act, or, if he did know it, that he did not know what he was doing was wrong. 2 paths: not knowing what you did, or not knowing it was wrong. Either one, proven, and the law lets you go. These become known as the Monckton rules. American courts adopt them within years. By the 20th century, the Monckton standard forms the backbone of insanity defenses across most of the English-speaking world. Some jurisdictions add to it, some strip it down. Almost none discard it entirely. Monckton himself never sees a courtroom again. He's committed to Bethlehem Royal Hospital, the asylum whose name gave English the word bedlam. Later, he's transferred to Broadmoor, a new institution built partly because of cases like his. He dies there in 1865, largely forgotten, his name now permanently attached to a rule he never asked to create. The rules sound simple. In practice, they've never stopped being a fight. What does it mean to know something is wrong in a legal sense versus a moral one? Can a person understand an act intellectually and still be incapable of stopping it? Psychiatrists have spent 180 years arguing that the Monckton framework doesn't match how the human mind actually breaks down. Lawyers keep using it anyway, because nobody has agreed on what should replace it. Modern insanity defenses barely change the formula. Courts today still ask a jury essentially the same 2 questions those 15 judges wrote out in 1843. Did the defendant know what he was doing? Did he know it was wrong? Every time a high-profile case invokes an insanity defense, the same rules resurface, the same public anger resurfaces, the same argument about where responsibility ends and illness begins resurfaces. A verdict from one furious winter in London still decides, today, whether a courtroom calls something a crime or an illness. 2 questions, 1 dead secretary, 1 forgotten woodturner, still unresolved.